Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guests today are Roy Shapira, professor of law at Reichman University, and Yaron Nili, professor of law at the University of Wisconsin. We'll be discussing their new article, Specialist Directors, which is forthcoming in the Yale Journal on Regulation. As always, I'll add a link to the article in the show notes for the episode. Roy, Yaron, welcome back to the Business Scholarship Podcast.
Pleasure to be here. Thank you for having me on there.
Roy, Yaron, over the last few years, Boeing, this really storied company in American engineering and industrial accomplishment and might, has had scandal after scandal in terms of the safety of its aircraft. Listeners are probably familiar with issues surrounding Boeing planes and doors in the last few months. You open this article with an earlier series of scandals, tragedies associated with Boeing and its mechanical engineering, deadly crashes in 2018, 2019 involving its 737 MAX airplane. Could you situate that tragedy in the context of this project and the context of corporate governance?
Sure. So this is Roy here. I'll have a crack at it. So the link between airplane crashes and corporate governance is a legal doctrine called director oversight duties. And the idea is that corporate boards are the organ in charge of risk oversight. And so whenever a company is involved in a fiasco, shareholders can bring a derivative action against the directors for not doing enough to prevent the debacle, for failing to engage in oversight. And this is exactly what happened with Boeing. The company suffered, of course, financial and reputational harms in the billions following the MAX 737 crashes. And shareholders wanted to hold directors accountable for it. And in 2021, the Delaware Court of Chancery allowed this derivative lawsuit to proceed, rejected the motion to dismiss, and the defendants rushed to settle. So what is unique about this case in terms of corporate governance? The Boeing case immediately received attention in corporate governance circles for the obvious two reasons, meaning first, the decision to reject the motion to dismiss reflected a new approach to director oversight duties, reflected an increased willingness to fault directors for not doing enough. And second, the settlement amount, around $240 million, if I recall correctly, was by far the largest ever in such cases. But the third aspect, a much more peculiar aspect of the Boeing settlement, went completely unnoticed. And that is that aside from the payment, Boeing committed to appoint a new director with expertise in airplane safety and to ensure that going forward, at least 3 of its directors would have aviation or engineering or product safety experience. And that was super interesting for us because basically what we see here is litigation pressuring Boeing to add specific types of expertise to its boardroom. And that is unique because in the past, to the extent that settlement agreements included commitments to implement behavioral changes, it was usually about adding independence to the board, such as the companies committing that going forward, the majority of the board will be outside independent directors. And here we're seeing a requirement to add specific types of expertise. And we saw it as an important signal, an indicator that a shift in how companies treat board expertise is already underway and is likely to intensify. And this is when we started.
There's a lot of literature, and I think we've explored some of this literature on the show in the past around the push for corporate America to diversify the characteristics of the individuals who serve as directors of those companies, particularly in terms of gender, racial background, sexual orientation, etc. Your paper focuses on perhaps a different kind of diversity in the context of who's serving on boards or stereotype breaking in terms of who's serving on boards, which is focused on perhaps the skills, the professional backgrounds of folks who serve as directors. I'd like to maybe think about this temporally a bit. Before maybe 2002, what was the typical composition of a large U.S. public company's board? Perhaps stereotypically that might be men, older men, older white men. But in terms of the skills and backgrounds those directors were literally bringing to the conference table in the boardroom, what sorts of backgrounds did they have professionally and in terms of the skills that they brought?
Okay, this is Yaron speaking. I'll take this one. So there are actually done a ton of studies about the specific skill sets that directors have brought. And I think the emphasis was less of an attention to that before 2002. But generally speaking, boards at the time had a fairly different approach to how to compose the board, in the sense that most corporations had a lot of executives that worked for the company serving on the board as well, right? So there's a lot of great papers about that transformation, moving from insiders to outside independent directors. And that switch happened around that time. Some companies have done it voluntarily before that, but a lot of companies had not only the CEO serve on the board, they also have their CFO, CTO, and likewise. And those directors brought important expertise to the boardroom in the sense that they were working on operational matters of the company. They had really intimate knowledge of what the company is doing. They had experience in those subject matters. When boards started to move into outside directors and then even more so into independent directors, some of those expertise might have gone lost or diluted in the sense that you brought people not necessarily that are very intimate with what the company does.
We talk about this maybe line of demarcation, 2002. What happened in 2002? What changes did we see in terms of regulation of board composition? What were some of the problems that new regulation was meant to address? And how did those reforms or new regulations actually do in terms of perhaps improving corporate governance going forward?
This is Roy here. So what happened in 2002 was a result of the wave of corporate governance scandals that Yaron just referenced, Enron and WorldCom and Tycom. The backlash to it, the response for these scandals came in the form of SOX, the Sarbanes-Oxley Act in 2002. And this led to the SEC requiring companies to disclose whether their audit committee members possess financial expertise. And similarly, stock listing exchanges started requiring companies to disclose whether they have a director with financial expertise. So to your questions, these requirements were geared at adding financial expertise, changing the board that Yaron just described in that regard, adding financial expertise to boardrooms. And the problems that these requirements try to address were classic agency problems. So if you have a series of scandals where, say, managers cook the books and lie to investors, you want to make sure that you have directors who are better equipped at detecting fraud, the directors who know where bodies are buried, so to speak, in financial reports. And there have since been, like you alluded to, Andrew, many studies by accounting and finance scholars examining how the requirement to add financial expertise has affected corporate behavior. Now, by and large, it was positive, but I think that the most interesting finding for our purposes, it's a precursor for our findings in the current project, is that it all depends on how you define financial expertise. The more positive results come when you appoint financial experts with accounting expertise, but not when you appoint so-called financial experts who do not have accounting expertise. And this is, again, a spoiler alert to what we're seeing in our project, where how you define and how you disclose expertise matters.
So we started seeing a real trend around directors bringing specific expertise to the table. How has that trend of appointing directors with specific skill sets or experiences or industry background or expertise, or at least touting those things, how has that developed since 2002? And what have been some of the pressures and perhaps impetuses for that trend? We've seen perhaps in the case of Boeing, it's appointed safety-minded directors to its board. What's been the impetus for that trend and the development of that trend over the last decade or so?
Yeah, this is Yaron. I'll take this one. I think we highlight in the project several different channels to reach the pressure on board composition has come. I would just say overarching, just generally, I think boards overall have become more of a focal point of interest from various interest groups, including regulators, including shareholders, including institutional shareholders, including the press. So boards, including courts too, we can see that with the Kermack type of litigation. So all of those different players in the corporate arena have paid more attention to boards, how they work, what are the composition of those boards. Specifically on the issue of skills, we highlight several different channels. I think the first one is just institutional investors and activist hedge funds, both kind of targeting boards for lack of specific expertise or setting expectations that board will have specific expertise, both ESG and non-ESG type of expertise. That's something that investors have started to pressure companies, either individually or as part of their voting policies and guidelines, to have more of that, and companies respond to that type of pressure, we know from existing literature. I think the second point is the SEC itself either signaling or proposing disclosure rules about specific expertise of directors. We highlight the cybersecurity disclosure rules proposal and how that might push companies to bring on board directors with that expertise, knowing that you have to disclose to investors whether you have a specific director or not is definitely something that companies are paying attention to. Third, as we started this episode, the litigation that happens on specific issues of failure, right? So when companies have catastrophic failures or significant litigation, that might bring about pressure to appoint specific directors to address those failures that were discovered during this litigation. So that's another channel that we highlight in the paper as far as how specific directors are being added to the board. I'll go back to my general point. I think generally there's more interest and attention to who are the directors, what they do. You started, Andrew, by noting that there's also been a lot of attention to diversity and race and other attributes of directors, but we can't disconnect it also from the attention to what directors do once they join a board.
This brings the focus of the conversation, I think, to your paper, Specialist Directors. Could you talk about the research questions that you delved into in this question, or the research questions that you asked in this paper, and introduce a bit of your empirical strategy to the listeners?
Sure. So I'll try. So the research questions are: one, how do companies respond to the pressures that Yaron just mentioned? So to what extent do companies actually change their board composition? And two, is that a good thing? Meaning, to the extent that companies respond, to the extent that companies add specialist directors, is it likely to improve corporate governance? Now, as for the empirical strategy, I think we need to take a small step back, because we're accustomed to seeing legal scholars, corporate legal scholars, focusing on board independence, but we see very few studies of board expertise or board effectiveness. And the reason is not because scholars find these issues unimportant. It's rather because scholars find these issues, say, lacking in data or how to capture a neat model. So if you're a scholar, it's easier for you to count heads. It's easier for you to count how many directors are independent. So we had to overcome these hurdles. So what we did is, first, to overcome the lack of data, we simply constructed our own data set. So we had a great group of RAs, shout out to them, and they went through all the S&P 500 companies disclosures in 2016, 2019, and 2022, and searched for any piece of information about directors' skill sets and experience. And then we coded everything. And to understand how this Excel spreadsheet that we created with the skill set, how it translates board effectiveness, to add context to the Excel spreadsheet, we also conducted in-depth interviews with practitioners. So we sat with directors who, say, had the nomination committee, or we sat with outside advisors, the so-called search consultants that boards use to help them locate candidates. And we asked these practitioners roughly the same set of questions, something like, do you feel pressure to add expertise? How do you add expertise? When you add expertise, how does it affect board dynamics, and so on? And there's usually an iterative nature for such interviews, meaning you come in and you expect to hear one thing about the director selection process, but then they'll tell you something completely different. And so then you'll have to go back to the drawing board, and you go back to the data set, and you test the new hypothesis, and so on and so forth. So that was the process, basically.
What were some of your key findings from that process, from it sounds like a pretty extensive review of the actual documents and the interview process with some of these actors? What did you find?
Yeah, so a few observations. Most of them are descriptive, but I think nonetheless very interesting. First of all, we see much more disclosure regarding the expertise of directors in companies' disclosures. Over that time period, we see a growth in the frequency of disclosure. We also find different places in which that disclosure happens. Companies often have the directors' written biographies. They have skill matrices that have really emerged over the last few years, and more companies are including skill matrices. They also have general skills tables, and sometimes they also include what we call an ideal skill table, basically telling investors what they look for in new directors as far as their skill set. That's one key finding. I think the second important finding is that companies are also disclosing on more types of expertise, right? So in the literature, in the classical literature, there's highlighting of several different types of expertise that people have paid attention to. We mentioned already financial expertise and so on. But now we see more types of expertise being disclosed, the ESG type of expertise as far as DEI or environmental expertise, also cybersecurity, which we already mentioned and so on. And so we see more of those types of expertise being mentioned. As far as what we see in the actual composition of board, we see an increase in the number of directors who are classified as expert in specific types of areas. Now, this is an important point because sometimes there is a lot of things that are going on when companies are crowning a director as a new expert. It could be that the director is just new addition. So the company is adding a new director that is an expert in the field. And some of the data that we collected definitely is that's the case. Companies adding new directors with that expertise. But we also identify instances where companies are basically rebranding a director. So director that wasn't disclosed as an expert in prior years is now being classified as an expert. And then it could happen for various reasons. It could be because that director before didn't think that it's important to know that they are expert in that. And now that there's more attention to it, they do. It could be that the director has decided that now based on some new experiences or exposure or training, now they view themselves or deem themselves as experts before they haven't. But we've seen all those things happen and go into what we see in the large sharp increase in the number of directors that are being deemed as experts. And there's lots of data in the paper. I'll just give an example. For the S&P 500, we see a huge increase with directors with cyber expertise from 25 in 2016 to 723 in 2022. 10-fold magnitude and increase almost in the number of those directors. I would say one point that connects to, again, a point that you mentioned before, Andrew, is the connection between diversity and expertise. We are cautious in the paper, but definitely for some types of expertise, there is a trade-off, right? And some areas have more demand and more scarcity of potential candidates. And that can lead to some skewedness in the way diversity is being impacted. In some areas, you're going to have to tap into directors that are less diverse because there's just less diverse directors that hold that specific expertise. So we also touch a little bit on the connection between the expertise of directors and how that impacts diversity in the boardroom. And finally, we also highlight how companies are inconsistent themselves in how they brand directors as expert or not. We show that the same director sometimes is being deemed as expert by one company, but not by the other company, that over time we see movements. We see companies just treating differently those different types of disclosures. Overall disclosure, public disclosure by companies, and something that I highlighted in previous project, is not something that we should be totally proud of. A lot of our companies are just not doing what they ought to do, or they're doing it in a very obscured way. And we found that to be the case also with the disclosure of director expertise in many cases.
It seems like there is a trend toward boards appointing specialist directors or reclassifying or reframing their existing directors as experts or specialists in a given area. That leads to a question about whether this trend is a good one from a corporate governance perspective. Is this a good development in corporate governance? And are there any potential drawbacks that we should be thinking about in light of this trend?
It's intuitive to think about the potential advantages of this trend of adding directors with new types of expertise, because at the most basic level, it could improve the quality of discussions of certain ESG issues that in the past never made it to the board agenda. So it can help boards be more proactive on these new topics. It can help boards know what questions to ask, anticipate future problems, and so on. And it can also help boards communicate better with shareholders and with stakeholders on these new ESG issues. And we know that ESG issues have been at the top of what shareholders wanted to discuss with boards in recent years. That's what the data shows. So having ESG expert directors lead the communications could help in that regard. But at the same time, I think we dedicate most of the room in the paper to highlight the counterintuitive, the less intuitive disadvantages of adding specific expertise. So first and most basically, I think many of the disadvantages stem from the basic fact that there's very limited supply of quality directors who are also experts in specific fields such as climate change or cybersecurity. So the number of individuals that meet the criteria is much smaller than you would have imagined. And so when all large companies are pressured to add expert directors, perhaps because of the, say, SEC proposal that Yaron mentioned, and they are pressured to add expert directors from a very limited pool of candidates, then many companies are bound to end up adding directors just for this specific skill set, but directors who have lower than average traits such as bandwidth, how busy they are, or understanding of the business. So in other words, the first worry, the most basic disadvantage is that adding a director with a narrow range of expertise can reduce the quality of board discussions on the other more relevant topics on the agenda, such as the general business strategy. And in fact, counterintuitively, when you add a director with expertise in a specific subject matter, it may also hurt the quality of board discussion on that specific subject because of something that psychologists call authority bias. Translated here, it means that, say that we appointed a new director who specializes in cyber or in climate. Now, all the other directors all of a sudden tend to overly rely on the opinions and the information coming from that perceived expert. They feel like, I don't need to educate myself. I don't need to keep apprised of what's going on in cyber and in climate because we have in this room this director and she will take care of these things. So that's the second drawback, the authority bias drawback. The third drawback has to do with the size of corporate boards. We're seeing indications that companies inject expertise into their boards by adding new members instead of by replacing old members. And over time, these constant additions of new members to the board could end up growing boards beyond their optimal size. So when boards become bloated, when they become too large, the communication slows down and the coordination and the ability to reach consensus become much harder and so on. The fourth drawback, I think Yaron touched it, so I'll just go over it shortly. It concerns board diversity, meaning that people who listen to this podcast are familiar with the push toward diversity in director demographics. And those who care about these efforts, Yaron has written about them extensively, should be mindful of how they potentially clash with the efforts to add specific types of expertise because of what Yaron said just a couple of minutes ago about the limited pool of candidates and how it could be predominantly male, for example, in one area. And the fifth and final drawback that we highlight is something that we call board washing. And it's just a play on greenwashing in the sense that by touting the addition of directors with expertise in, say, diversity or climate, the company can try to alleviate pressures to actually change its behavior on diversity and climate. In other words, the worry is that companies will use director expertise disclosure as window dressing instead of dealing with first order problems directly. The bottom line, of course, there are benefits and there are costs for adding specialist directors. And this trade-off is very company specific. But the general reason that we worry about this trend is that the on-the-ground changes are not company specific. The evolution of corporate boardrooms that we document in the paper is not necessarily happening gradually and organically. It is rather mostly a reaction to the outside pressures that we discussed like 10 minutes ago, from disclosure requirements to shareholder involvement to litigation. And so we worry that companies will fast track specialist directors into their boardrooms while compromising their director selection process and their director onboarding process.
I wonder if we could zoom out a bit and think about the implications for this trend towards specialist directors at a social level. What are some of those implications for corporate America and its role in society? Certainly, I think whenever I get on a plane next, if it's a Boeing plane, I might be thinking about this paper and this topic of specialist directors. What are the implications beyond the boardroom?
I think most broadly, I think that the implications can be divided into some specific recommendations we have for various groups, but also just a general observation on the importance of paying attention to the role of specialist directors, the shift towards more attention to specific skill sets being injected into boardrooms, how that might alter dynamics in the boardroom, how that might impact the way boards function. And I think the overarching point I think this paper is trying to make, and I think has been underappreciated, is that the changes that we observe, both from the data, from what we've seen from interviews, are really driven by outside forces. It's not an organic change that companies are doing on their own terms, their own timeline, and that has significant costs and potential disadvantages. Board dynamics are something that is really hard to quantify. It's really hard to be able to fix by you add one director like that and one director like that. It's really something that companies and directors themselves know and have the ability of understanding better than outside forces. So to the extent we are putting pressure on companies to change that dynamic by adding specific directors, that could have significant costs that we are concerned about. I think the second point is understanding if you are pressuring, you need to understand what you're pressuring for and what are potential trade-offs of that pressure could lead to. So as far as regulators go, we think that trying to specifically require disclosure about specific directors will have cascading effects on how companies compose their boards. And that's something that regulators will have to pay much closer attention to than maybe they have in the past.
What key takeaways or open questions would you like to leave listeners of this podcast or readers of the paper with?
So to me, this project is about the two biggest developments in corporate governance over the past decade. The two biggest developments to me are compliance and ESG. So we have companies facing increased regulatory and societal demands to treat their stakeholders better. And in response, companies are pouring billions of dollars into compliance programs. And when these costly programs nevertheless fail, regulators and investors and everybody are pointing fingers at the board of directors. So now what we're seeing is that the combination of these developments starting to influence the composition of corporate boards. Whether you like this development or not, companies are responding by disclosing more about the director's skill set and by adding directors with specific skills. And the open question that I'm sure researchers will dig into over the next decade is the effects of appointing specialist directors, the effect that it has on corporate behavior. So if a company appoints a climate director, does it increase the company's commitment to fighting climate change? Or if a company appoints a cyber director, does it reduce the likelihood that the company will be involved in large data breaches and face event-driven litigation? Something that we'll have to see over the next few years.
And I'll just add a couple of points. I think one other really big development in corporate law that I think this paper corresponds to is the dynamics between shareholders and companies. And that's like something that over the last 15 to 20 years really has evolved from a place where directors and boards were fairly insulated to a situation that maybe boards are over-responding to some investor requests. And that's what the paper is highlighting. The pressure from investor groups to have specific directors might have costs to companies, but they do it anyway. And when we talk to directors and such committees, and there's trade-off that they are aware of about this need to address expectations and what that means for their own searches for directors. So I think that's a key point that a lot of people are highlighting in various aspects. And this topic of director skill set is another instance where we see this push and pull between companies, regulators, and investors. And as Roy said, I think this is a very fertile place for continuing research on the impact and need for specific skill sets. There's a lot of research that can be done. We want to encourage other people to utilize our paper, utilize our data to go and continue investigating it over. And I have a couple of follow-up ideas for our own research as well. So I think that's an exciting new frontier to explore, something that needs more attention from academic research as well.
Our guests today have been Roy Shapira, professor of law at Reichman University, and Yaron Nili, professor of law at the University of Wisconsin. We've discussed their new article, Specialist Directors, which is forthcoming in the Yale Journal on Regulation. I'll add a link to the article in the show notes for the episode. Thank you for joining the Business Scholarship Podcast.
Pleasure as always, Andrew. Thank you.
Thanks for having us.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.